morning, everyone. Welcome back to another interview of our series in Family Legal. I am Madhvi Sharma, and along with me is my friend Sahil Gupta. We are both second year BA LLB students from the National Law School of India, University, Bangalore. Today, in this podcast, we aim to shed light on a very critical but often overlooked aspect of divorces under any law, which is the role of mediation and ADR mechanisms. To help us unpack this entire intricate process of how mediation works, we are honored to have with us Ms. Rukmani Menon. Thank you so much for joining us, ma'am. Ms. Menon has over 25 years of experience in matters pertaining to both civil and commercial matters. She has also worked with the Camp Mediation Desk and the State Commission and the District Consumer Commissions at Bangalore since 2017 onwards. She is also a mediator at the Bangalore Mediation Center and has mediated over 450 cases in a wide range of matters. She is also a member of the mediation panel attached to the NCLT Southeast Division. We are very grateful to have you here, ma'am.
Thank you so much. Thank you so much for having me.
In this podcast, we will be discussing the role of mediation in marital disputes, including its viability, challenges posed by cultural stigma, and handling issues like cruelty and domestic violence. We will also touch upon the complexities of using mediation in sensitive cases and the need for greater awareness and reforms to make it a more effective tool in family law. Madhvi, can you please start with the questions?
Yes. I think just to get this started, we want to understand what the process of mediation looks like and how do you generally go about employing that in matrimonial disputes, typically divorces.
Okay, thank you so much. So mediation is a facilitative negotiation in which a neutral mediator assists the parties in reaching an amicable resolution to their dispute, and the outcome is entirely in the hands of the parties. The mediator is not a judge, the mediator does not decide. The mediator is only facilitating, and it is a process which is very cost effective and time effective. Like, I'd like to give you an example. If it is a contested divorce, under any law, be it the Hindu, Christian, or the Muslim law, if it is contested, it takes about 3 years in the lowermost court, and if there's an appeal, another 3 to 4 years, so 7 years. As against this, mediation, be it in the court annex program or be it in a private mediation, it does not take more than 3 to 6 months. So it is cost saving, and it is time saving and stress saving for the parties involved. Not only the spouses, but the children also. And the best part of it, it's a voluntary process. The parties can, suppose at some point, it's happened also, some point of time, parties say, no, this does not suit us. We rather have somebody taking a decision, and they go back to court. But in my experience, I've seen lots of parties who go back to, see, we can't as mediators force them to sit there and mediate. So when they go back to court, it so happens that they know a little bit about how the mediation system works. In my experience, parties who go back, about 75% come back to mediation because they say, like, we can't go on with the court process. It's a confidential process, so that helps the parties in, very clearly speaking their mind without hesitating. Because at the end of the day, being a party-centric process, it is the parties who do all the talking in the mediation, all the speaking in mediation. The lawyers are very much required for giving them legal support and giving support to the mediator too. And the mediators are neutral, as I already explained. The neutral does not show any kind of favoritism to either of the parties. So
Right.
that's in short about mediation. And mediation, your second part of the question was, mediation can be used for any kind of dispute, be it a matrimonial dispute, a commercial dispute, a workplace dispute. So in matrimonial dispute, a whole lot of, it's not only the divorce which gets sorted out, child custody, maintenance, If there are certain other, domestic violence cases which may be coming up, all that together get sorted out in mediation.
Right. I just had a small follow-up to this. So, in case of any matrimonial disputes, at what stage do the parties actually decide to go for mediation? Is it at the very last ultimate stage where things have gone very bad and they're going for divorce or something similar? Or is it at the initial stages that one goes for mediation?
That's a very good question. So parties have a choice. There are some, like I'm recently starting with a mediation where parties get to know, maybe from the lawyers, maybe from their friends, or maybe they visit websites of private mediation centers like CAMP. They get to know that there's a process like mediation. Now, parties, what happens is they don't want to get into a very bitter dispute. So before going to court, they see if they can go in for what is called pre-litigation mediation, where if both parties have consented, have agreed that yes, we cannot live together and we rather go in for a divorce, then in pre-litigation mediation, all the terms and conditions regarding alimony for the wife, the child custody, child visitation, child maintenance, property issues, everything gets sorted out there, and terms and conditions can be sorted out in pre-litigation mediation in a short period of time. And with those terms and conditions, the parties can file a mutual consent divorce. And it can get sorted out. Now, there are other cases where one party is agreeable, wants a divorce, the other party is just not agreeable. Then they have to go to court to file a contested divorce, in which case normally the court send the parties for mediation to the court annexed mediation center, and over there the mediator then starts with the case. So one problem, I would like to just say something about this, that when the judges say you have to go for mediation, so when you tell them it's a voluntary process, one question that they all ask is that you are saying it's voluntary process, but the judge said you have to go. What do you mean by this? Then isn't it contradictory? So when we say it's voluntary, it only means that they're coming into mediation, sitting and understanding understanding about the process is mandatory. But whether they want to continue with the mediation, whether they want to reach a settlement is extremely voluntary, and nobody can force them to do that. So that is the difference. And even in parties have the choice for pre-litigation mediation. They can go to individual mediators. They can for private mediation, they can go in for mediation centers like private mediation institutions like CAMP. And even if they are in court, I have not seen many occasions, but there are some parties who tell that we would rather go in for private mediation. Why? Because private mediation, you have a choice of your mediator. There are rules and regulations. Not that in the court annex there are no rules and regulations. The High Court has rules and regulations which streamline the mediation process. Only big difference being you have a choice of mediator in a private mediation center. That's the main advantage. So these are the different stages. Yeah.
So, ma'am, as you have said that there is a, like, now people are getting know of mediation in disputes through websites and through CAM and through other mediums also. So there is a growing push for mandatory pre-litigation, mandatory, especially in family disputes, whether it's a divorce case or some other case. So as a way, this is to reduce the burden on courts and engage and encourage amicable resolution. So in your view, is this a viable solution? What potential risk and benefits do you foresee, particularly in the context of divorce cases where complex cultural and emotional dynamics are often at the play?
Okay. Now, let me just clarify something. You are saying mandatory pre-litigation, right? Now, mandatory pre-litigation is, the word mandatory, please understand the significance, is only there at the moment under the Commercial Courts Act under Section 12A for commercial cases, not for matrimonial matters. Matrimonial matters, it is the parties who themselves come in for pre-litigation by becoming aware of the process by any means when they're not able to settle their terms. But if it is a contested divorce, they usually one of the spouses, either the husband or the wife, lands up filing a divorce petition on grounds of cruelty or desertion in the family courts, and from there they are referred to. They have to come in for mediation. That's what I explained, that they're coming in for mediation is mandatory, but for staying there, for arriving at the terms and conditions, it is voluntary. And you also asked me about, how does one, am I right in understanding that you asked about how does one deal with difference in cultures and etc. in a mediation,
Yeah, yeah. The
right?
question generally,
Yeah,
the
so
question
when
is
you
tracking
say
at that.
that, assume you mean when they are intercaste marriages, etc.,
Yeah,
or
even
cultural,
interreligious marriages also.
interreligion, or cultural. So what happens is mediation is a very flexible process. In fact, all these kind of differences are sort of better looked into in a mediation. Only in a mediation are the underlying interests of the parties looked into. Whereas in court, what does the court go by? The court goes by the plaint file, the written submission to that plaint, to the various documents, etc. In mediation, it is actually you go into the emotional part of it. What do the parties want? What is exactly what are their interests and why is it they want the divorce? So whether it is cultural differences or caste differences, that is definitely much better taken care of in a mediation, because it's an extremely flexible process which takes care of all such nuances.
Right, ma'am. That makes much more sense because we were under certain different perception that the mandatory pre-litigation is also mediation is also there for matrimonial disputes. But I think as you emphasize the voluntary nature of the mediation matrimonial disputes, now that makes a lot of internal sense. So in that context, I also wanted to know if you've come across certain unique challenges in mediating matrimonial disputes. Like you mentioned, there are a lot of other family law cases including custody, etc. So, in specifically mediating matrimonial disputes, what are the sort of challenges that crop up? And as a mediator, how do you deal with them?
As I explained before, matrimonial will include all this. It's not only the divorce. It is child custody. It's everything which comes with it. So, we do come across hurdles. Uh, in the sense, what happens is, if I'll give you a typical example, you have a husband filing for a divorce, yeah, and immediately you see a number of applications filed by the wife. It could be for 98A, which is for dowry, it could be maintenance, it could be domestic violence, etc. So it's like what do you call it? It's kind of repercussion to the, or a kind of reaction to the, not repercussion, a reaction to the divorce being filed by the husband, that all this is filed to counter it in case in case she doesn't want to sort of give a divorce, or if she is looking for higher alimony. So the hurdles we come across is when one party is insisting on a divorce, the other party is point blank refusing. Could be because of a social stigma, which mostly is from the woman's side. that I cannot, the society will not accept me as a divorced woman. And the second aspect which we very commonly see which becomes a hurdle is that a divorce would impact children very badly. The children need parents. But what these parents don't realize is that children growing up in an extremely toxic marriage is nothing very great for them. Whereas if these parents are separated, and both, see, parents will remain parents. Just because the husband and wife are getting divorced does not mean that they give up their rights on children. So, in fact, if they're separated and they have visitation rights, the children are more at peace. They don't see the husband, their parents accusing each other, behaving badly towards each other, using the children as tools, to fight against each other. So, we generally call this in our mediation term as impasses, and we come across numerous impasses. Could be even from the respective families of the husband or the wife. And one thing we all notice is that in India the culture is such that when two people get married, it's not only the husband and the wife getting married, it is two families getting married. And there is so much interference in their lives that at times it is this unwanted interference which leads to couples breaking.
Right. I just had a follow-up, especially in the context of mediation. Like you mentioned, in India, it's not just the individuals getting married, but it's both the families. So, have you come across any cases where the family itself materially tries to interfere with the process of mediation? For example, requiring to be present in the mediation process. Have you ever seen such situations? And if yes, how do you deal with such situations? Because in the West, I think the culture is slightly different. You don't see such situations very often.
No, not at all. In India, I can say very confidently, 70% of the parents are there to just sort of, 70% parents come in. They have a huge say in what the terms and conditions should be. Though, at times you see that the couple is not even talking much, is the parents talking much. When we see this, then as mediators, we request the parents that first we would like to talk to the couple separately. We'd like to talk to the couple separately. Please give us some time with the couple. We sit with couples and ask them that what is it, what's happened? What is it you want? And how do you want to go further? Is it, you decide, you are adults, you decide. It's not that at 35, 40, you need your parents deciding for you. You have to, in mediation, we cannot give direct, as mediators, we only facilitate. We have to ask the right questions to gather information. So by asking right questions, we gather information by asking open-ended questions. We can't tell them don't do this, but we ask the parents that if you don't mind, we'd like to spend more time with the couple. And then we ask the parent. We always ask, when you ask one of them that, can you tell us what exactly went wrong with the marriage? Can you tell us that what is it you expect? And there are a lot of people who parties are very willing to talk. And then we do private sessions with parties where they share information which they do not want to share in front of the other side. So with all this, it is quite a challenge. But when you gain experience, then you sit with the parents also separately. And, sort of make them realize that what the couple is deciding is best for them.
Yes, ma'am. So I have a question now. so there are cases of cruelty and domestic violence, and in cases where there are allegations of cruelty or domestic violence, do you find mediation to be a suitable forum for resolution? Like, how do you sort of create a safe and non-judgmental space for addressing for addressing these issues with legal seriousness?
Now, cruelty is one of the grounds based on which a contested divorce is filed. Now, 85 to 90% it is mental cruelty. It does not necessarily mean physical violence or anything like that. It's just mental cruelty that, the person is not allowed. It could be either a spouse is not allowed to live life the way they want. They're very controlled. They're not given money, and lot of things that, their old parents are insulted. Things like that. That the children are not allowed to meet grandparents. There'll be hundreds of such things. So mental cruelty is always a ground for divorce, and this is very much taken up in mediation. And as I mentioned previously, you cannot directly see. There's not a cross-examination mediation. Mediation is a process of gathering information by listening and by asking the right questions at the right time so that the parties are willing to come up with the right information. Now, as far as domestic violence is concerned, so again, it's something which can be very much dealt with in mediation, again, by asking the right questions that, if there has been physical violence, was it reported? Is there a police complaint? Was there a visit to hospital? So what happened? And then also asking the right questions of the husband, that this is what is being said. So what do you have to say about it? It's the way it is handled. Again, here it is a question of I have had. I mean, that was one of the very odd incidents I have seen in one of my mediations, where the husband very openly said, "Yes, I beat her up." And these two were software engineers. "Yes, I beat her up because she is very irritating and she irritated me. So I beat her." I mean, just like that. So that was a very sort of, shocking kind of thing to hear. Quite a few husbands try to say it's a wrong allegation. It is just sort of being, cooked up. So when you say there was a police complaint, why was there? I mean, can you explain about the police complaint? So there are ways of handling this. I would say majority of the husbands say there was domestic violence, and it can be handled well in mediation. Again, I'm repeating, by asking the right questions. And see, it is a question of, are you making this domestic violence a reason for your divorce? And if yes, then ask the wife would have filed for a divorce. Ask the husband that, do you expect your wife to continue on in a marriage where she says she's being physically abused? So what would you do if you were in her shoes? How would you respond? Things like that. So the whole thing is always about, listening. Communication plays a great role in mediation. And the problem with any dispute is the parties in dispute have stopped communicating with each other. So this communication is restored in mediation. And sometimes we sort of, make sure that the parties won't have met each other, talked to each other for months together. So when they come face to face, there are parties who, would like to talk to each other without anybody being there, only in the presence of the mediator, without the uncles, aunties, and parents, etc. So they're given an opportunity to do that. I have come across couples, we do online mediations also, who say that we do not even want to face each other online. There is so much of bitterness between them. So then what we do is we do mediation in private sessions, so that they don't have to face each other. Because they say, if we face each other, it will again start off a major argument, a fight, and we never move forward because we never agree on anything.
Right,
So
ma'am,
these,
I think
yeah,
I'm so sorry to interrupt you. Please go ahead.
no. That's what I'm saying. So it is both these are both these are very much can be handled in a very good way in mediation.
I have a question like what are the gender-based dynamics during a mediation process and the initiation of mediation process? Like where this does this push for mediation generally come from? Is it initiated
Okay.
by the husband or the wife, or like is some concerned member of the family also like can try to initiate it on their behalf?
Okay. Now, as I explained in earlier, if there's a case pending in court, then the court directs you to go in for mediation. Okay, so court is the is the mechanism through which they come for mediation. Now, this is a different scenario if, as a pre-litigation mediation, that could be initiated either by both the parties together if they have mutually decided, yes, we want to go in for a divorce, but they're not very sure about how to put down the terms for separation regarding commonly owned properties, regarding children, regarding custody, maintenance, etc. So they generally they ask the lawyers, how do we go about it? Sometimes they do sit with the lawyers, but if they can't each lawyer will support his or her client as far as these terms are concerned. So it is always better having a neutral party there who can help them negotiate these terms better. Sometimes it is, as you said, a concerned relative who's heard of this process who will reach out to private mediation centers like CAMP and say, see, my nephew, my son, etc., or my daughter is going through this problem. I've heard about this process. I saw your website, or they will sort of get to know about the process of mediation. They will go and search online. They'll Google, and they will see who are the mediators available, and that's how they come in for mediation. It could be either at the initiated either by the couple, initiated by a concerned relative, or even lawyers tell them to go in for mediation at times.
Right. That actually makes a lot of sense. Now, I wanted to just segue into a couple of procedural questions about how the process of mediation plays out. One, I think in the previous answers you'd mentioned that mediation is all about asking the right questions at the right time. So how do you generally prepare for these sort of um, sessions? And as you mentioned, you also take private sessions. So how do you ensure that how do you frame the right questions, so to say, and how do
Yes.
you ensure that the session goes forward consistently and is not stuck at any point?
Okay, again, a good question. See here, as far as court goes, as far as court mediation center goes, there's very little time for preparation per se because allotment is done on first come basis. Like on a given day, if you go in as a mediator, there is some file, it's handed over to you, right? Whereas, over here, how the process works is so you start gathering, you sit with the couple, make an opening statement, tell them about because they don't know anything about mediation. Make an opening statement, tell them about the process of mediation, ask them for the doubts. Then you start, gathering information from both the parties by one thing to be understood, this is not an aggressive question answer session. That why is this I did that? No, it is always that, okay, help me understand what went wrong with the marriage. What is it, what is it you would like to do about the children? How would it affect how in your opinion would it help the children if you separated? And what is it, you would need so that your future financial security is there for you, things like that. So asking the right questions is put in such a way. See, I'll give you a simple example. if I were to ask you, suppose you are a visitor to Bangalore. If I were just to ask you, do you like Bangalore? What would you say? Yes or no, right? That's called a closed question. Whereas if I put it to you like this, okay, what what are the things you liked about Bangalore? Then you will start coming out, I like the weather. So what is it about the weather you like? I liked the parks. So which park did you like better? I like the different cuisines. So what happens is if you put out these type of questions, one leads to the other, and the party comes out very willingly with all information. So there are questions which you ask generally about facts in a joint session where both the parties are there. Maybe some parents are there, the lawyers are there. Now, there are some parties who say that we want to talk to you in private about certain things. So then we break up the session, have private sessions with both the parties, especially when it comes to negotiating terms. The parties want to sit with you separately because the wife says, okay, I want so much alimony, I want the kids, I want blah, etc., etc., etc. The husband will then, you go back to the husband and say, okay, what do you think? We do it straight away. We ask in private sessions, we ask each party, how much of the information you've given us can you reveal to the other side? So it has to be done in a way that you do not breach confidentiality at any point of time. So you put it in a way that without breaching confidentiality. So suppose the wife is asking for 50 lakhs alimony. And then, you have to ask the right questions. How much is your husband earning? And what do you think he has the capacity to pay the 50 lakhs? And etc., etc. I'm just giving you an example. So when you come back to the husband, you say, okay, how much is it? What is your position? In what position are you working? How much do you earn per month? And we straight away don't say husband is his wife is asking for 50 lakhs. So how much do you think that you would be in a position to pay as alimony? So it's a question of very questions asked in a very, very different way so that parties are willing to come out with information without any fear that they're being, grilled, right?
Right. And ma'am, I had another question. So during my internship at camp, I had a brief discussion on how there are biases in the process of mediation. So we're all humans at the end of the day. The mediator, both the counsels, both the parties come from certain vantage points. So as a mediator, one, how do you ensure that you yourself are sort of seated at a neutral position? And two, how do you tone down the conversation and get both the parties talking at the table? How do you balance this bias situation in the process?
Oh, bias is, as you rightly said, we all are human beings. We come with our inborn biases. This is just something which you have to develop over a period of time. See, you may have a lot of personal views, right? But you have to keep aside your personal views when you sit as a mediator. Like, for example, I mean, personally speaking, as far as I'm concerned, I think that it's so much better if women are financially independent and they're working. But that does not mean that if the wife is a housewife, I'll keep that in my head and say, oh, what are you doing? Why are you wasting your time at home? No, every person has their own choice. So understand that there are a lot of women who are professionally qualified but still at home. So you ask them that what is it? I mean, is there any reason why you're not using your qualification? And would you be working at a future point of time? See what the present um, uh, Supreme Court has come out with, that even if the wife is currently not working, if she is capable of working, so the alimony should be granted accordingly. So it is, those kind of things that biases are difficult to, like, for example, as you said, a husband who regularly physically abuses his wife. You can't have that thing, oh my God, what a horrible man. He's beating up a woman. So instead of that, you say that, this is what your wife is saying. What do you have to say about it? Is it something, what is it which made you raise a hand on your wife? So you can't let your personal biases come in ever. And there are certain complaints of child abuse against the father. Usually what we do is, if it is seriously a POXO case, we don't, and then we say that we will leave that aside totally. We will concentrate on the divorce. If you're okay with that, we can go ahead. POXO and all cannot be mediated because it's a criminal offense, which cannot be. There are some criminal offenses, like for example, 498A dowry is a non-compoundable offense. But what happens is, and it's always filed by the wife, suppose the parties are reaching a settlement in the divorce. And if the wife, you can't withdraw 498A, but the wife can turn to be a hostile witness and appear before the magistrate's court and say, I no longer want to continue with the complaint. Alternatively, the husband will file for quashing and she will cooperate with the husband in getting it quashed. So all these things have to be kept in mind, for this particular thing of bias and what's the other thing you are saying? It's mainly about bias, no? Yeah. So you
Right.
have to. It's a very tough call, but as you gain experience, you learn to do that.
Right, none that makes sense. I had another very brief question. I'm just too curious to know. So in law school, we have these mediation competitions, and we see that we're told
Yeah.
that as legal counsel, you don't have to be too dominating. There's like a 20/80, 30/70 sort of split, where the party gets to speak more. But I think in real life, where the stakes are much higher. So just in your practical experience, are the counsels dominating, so to say, in the mediation process? Or is it mainly party driven, the actual process of mediation?
See, as I'm talking about from my personal experience. I always tell lawyers, see, you should never make lawyers feel unwanted. But you always say this is a party-driven process. So if you don't mind, we let the parties talk over here. See, parties never get a chance to talk in court, do they? They don't. It's always the lawyers arguing, right? So we say it's a party-driven this thing. We would. It is your duty to lawyers. I mean, encourage them, help them negotiate. Help them negotiate for the right terms and conditions. Help them in moving forward without creating obstructions in the mediation process. If there is a legal issue, see, if there is any kind of a legal impasse, the parties don't know the law. So many people, so many of these parties will ask, so what is your suggestion? So we always tell them, we are not here to suggest or give you legal advice. Ask your lawyers, they're the best people to advise you. So in mediation, it is a party-centric process. So it is the parties who should be given the opportunity. Lawyers are there to back them up, to coach them, so that they give the right information at the right time and negotiate the right.
So just to conclude this, I have one last question. Like, what are the enforcement mechanisms? This is a very general question. It's not only for the divorce, it's for the whole of the mediation process. So what are the enforcement mechanism, or what are the mechanisms that after the resolution is passed, parties both bind to it? And a more general question is, how do you see the future of mediation in Indian family legal system and Indian family law? Like, do you think there is something needs to be changed to increase its efficacy, or do you think it's like fine as it is working? What's your view on that?
Okay, so first part of the question, as far as enforcement goes, if it is through court, if the mediation is coming through court, what happens is the settlement agreement goes back to the court and the court passes it as a decree. So that decree is enforceable as a court decree, right? Now, if it is in private mediation, it is, see, anyway, in a matrimonial matter, if they agree on terms and certain terms and conditions, the mediator cannot grant a decree of divorce. With those terms and conditions, anyway, they have to go back to court and the court will have to pass a decree on those terms and conditions, right? And one thing I'd like to tell you is that, as you both are aware, the Mediation Act was passed in 2023. And I don't remember the exact section, but any settlement agreement reached in mediation is like a court decree and can be enforced under the CPC. And the future of mediation, I would want to say the future of mediation looks very good, whether it is matrimonial, whether it is anything else, other disputes. Why so? One is because the Mediation Act has come. Moreover, our courts are there's too much of pendency of matters. If, if certain number of are resolved in mediation, it lessens the burden for courts. And moreover, at the end of the day, if matters are resolved in mediation, there's finality to it because there's no appeal. There is no win-lose. Mediation is always win-win for both the parties because they are the ones who negotiate the terms for resolving the dispute. So future is very bright. See, I would like to give you an example over here. Italy is one country where the pendency was much higher. And Italy adopted mandatory mediation, and now the pendencies come down to 60% of what it was. Even if we don't have mandatory commercial courts, there is mandatory mediation. Even if you don't have mandatory mediation, mediation is slowly picking up. And I'm sure that whether it be family matters or other matters, there's a very bright future for mediation in our legal system in the coming years.
Right. On that note, thank you so much for your time today. We are so grateful that you could make time for our interview in such a busy schedule of yours, and we're so grateful for your insights. This is this is a great interview. I think we could talk about complex issues of gender dynamics, cultural issues, and also the procedural aspects of how mediation works, how to frame the right questions, how to ask them at the right time, the counsel party division, and most importantly, the voluntary and willful and party driven nature of this entire process. We are very sure that this interview will be very insightful for all our viewers. And once again, thank you so much for your time. We're very grateful for it.
Thank you. It was a pleasure being here. It was a pleasure answering your questions. I hope mediation, a lot of awareness needs to be spread. So you're doing a good job that by having interviews like this, you increase the awareness amongst people, be it advocates, be it students. You are the future of coming future of our country. So if you know mediation well, you can encourage your clients to try mediation. Thank you.
Thank you so much,
Thank you, ma'am.
Thank you.